In the previous video, I have covered the issues of concept of law and have introduced to you the debate between two main schools of thought in legal philosophy. In this video, I intend to dig into certain accounts from legal positivism school and also from national law school. However, before doing that, I would like to reinstate again the essence of the difference between these two schools. Nevertheless, it should be noted that even when certain philosophers are categorized into the same school of thought, their accounts of law or what law is will differ from one philosopher to one philosopher in the same school. When talking about the essence of the difference between legal positivism and natural law school, uh, we're trying to identify the difference between the shared point agreed by national law theorists and the shared point agreed by legal positivists. The essence of the difference between these two schools, as have been explained in the previous video, is that natural law theorists shadily argues that there exists the necessity between law and morality or justice. So this means they reject the separation thesis. On the contrary, legal positivists argue that law and morality can exist independently from each other. Thus, they support the separation thesis. To provide more detail on the national law theory, let me begin with one of the most influential philosophers in the Roman era, who is Cicero. According to Cicero, true law is right reason in agreement with nature. It is of universal application, unchanging and everlasting. So this means that national law apply universally to everyone, to every human being, and to everywhere inside this world and perhaps, possibly, beyond this world also. And it's unchangeable and it is eternal. According to Cicero, it is a sin to try to alter this law, nor it is allowable to attempt to repeal a part of it, and it is impossible to abolish it entirely. We cannot be free from its obligation by Senate or people. So it means that even by the one who hold the power of the state, the sovereign power, we could not be released from such a law, even by the parliament who is elected by the people, or not even by the people themselves. All right. And according to him, we need not look outside ourselves for an expounder or interpreter of it. So he tried to argue that as a human being, we have a capacity to know the contents of natural law and understand them. And according to him, he tried to refer God as a source of law. So according to him, there will be one master and ruler, that is God, over us all. For for he is the author of this law, is promulgator, and is enforcing justice. However, as you might have studied Cicero before, God, according to Cicero, is Logos. which means the underlying reasons behind everything in this universe. So the basics of natural law is the underlying reason behind this whole universe. Logos. Moving to Aquinas, who was the saint in Christianity living in the medieval age. Aquinas defined law as a certain rule and measure of acts whereby man is induced to act or is restrained from acting. According to him, law is simply a dictate of practical reason by a ruler who governs a perfect community. And from the point of view of St. Aquinas, the supreme ruler of the community of human beings is indeed God. Thus, Aquinas divides law into four types. First, the eternal law. Secondly, the natural law. Third, the divine law. And fourth, the human law. The eternal law is the supreme law, which is the God's reason. The natural law and the divine law are subparts of eternal law. What are the difference between natural law and the divine law is that we propose human beings propose a capacity to completely understand the national law as a part of the God reason. However, due to the concept of original sins, we have lost some capacities to understand God's reason, and this is why we could not understand divine law. Think of divine law as a certain rules, some rules that are written in the religious book that you might not think that it are reasonable, but from this perspective, it means that this is not reasonable. But perhaps it is because it's beyond our understanding. But if we keep practicing them, ultimately, finally, uh, we could we could reach God by keeping the faith in God or what is written in the holy religious book. For example, the last one is the human law. Uh, the human law are necessary for two main reasons. The first one because national law or the idea of morality deal with or what is right or wrong. However, uh, to make the law effective, we need to provide a legal enforcement mechanism, which is not really based on the idea of right, what is right or wrong. And uh, the second reason is that sometimes in our life, we need to deal with the problem with not relevant to morality. For example, uh, in which side on which side of the street that on the road that we should dive, right or left side. This is not about what is right or wrong morally, all right, but we have to deal with or we have to set a rule about this problem of coordination of our life, all right. And so after discussing Cicero and Aquinas' account of law, I would like to spend some time on the necessary relationship between law and morality, which is the thesis proposed by national theorists. There are at least three types of necessary relationship between law and morality proposed by different legal philosophers who are categorized as national law theorists. The first one is that national law serve as an ideal law for positive law, which means Natural law is a form or blueprint of perfection for positive law. So, accordingly, positive law tries to develop its contents or feature to be exactly the same as national law because national law is the goal or the blueprint of the positive law. The second type of relationship is that national law serves as a higher law for positive law, which means if positive law conflict with national law, such positive law becomes void. All right, become void. Thirdly, national law and the basic as the basic of moral thought for the positive law. If the positive law conflict with national law, such positive law lacks moral force. But whether it is legal valid or not depends on whether it meets the conditions set by the legal system. All right. So this is the two types of necessary relationship between positive law and national law, or in other words, between law and morality. All right. As an ideal law, as a higher law, or as a source of moral force or positive law. National law as a sort of moral force for the positive law. All right. And then let's move to the other school, legal positivism. One of the very famous account which is often criticized by other philosophers or theorists is John Austin. John Austin was the late John Austin is was a former professor of law at University College London, UCL, and because he was responsible for teaching the class called, I think, general jurisprudence, perhaps. All right. So he needs to define the concept of law because it is a subject of study of his course. All right. So he proposed that law is a command of a sovereign. Uh, Basically, why he proposed this concept because uh, the essential features of law which might make law different from other social norms. It is legal enforcement or the binding force of law. But what will contribute to the binding force of law? Of course, from one sense, the power is necessarily element to enforce the law. And so if we ask who could make the law that can apply in the state, of course it should be the one who had the supreme power of the land or a sovereign. So according to Austin, law is a command of a sovereign. All right. Austin said that every positive law or every law simply and strictly so called is set directly or circuitarily by a sovereign individual or body to a member or members of the independent political society wherein its author is supreme. In other words, it is set directly or circularly by a monarch or sovereign number to a person or person in a state of subjection to its author. Of course, based on this concept of law as a command of a sovereign, it's attract a lot of criticism towards Austin because one of the weakness of this account is that so there is no limitations of the contents of law that is that is ordered by the sovereign power holder. All right. Another philosopher who is very influential in the school of legal positivism is H.L.A. Hart. But unlike John Austin, he Hart does not base his concept of law on the idea of supreme power or the idea of sovereign power, but based on the internal point of view. But what is internal point of view? All right, he said that uh, he wrote that what we have called the internal point of view, the view of those who do not merely record and predict behaviors conforming the rules, but use the rule as standard for appraisal of their own and other behavior. This requires more detailed attention in the analysis of legal and political concepts than is had usually received under the simple regime of primary rules. The internal point of view is manifested in the simplest form in the use of those rules as the basis of criticism and as the justification of demands for conformity, social pressure, and punishment. Hart have criticized many features or many points of the idea of law as a command of a sovereign proposed by Austin. All right. Uh, One point that Hart used to criticize Austin is that law sometimes doesn't derive from the supreme power holder or the sovereign. Of course, if we look into the past, we can see that one important form of law that governed the primitive society is, of course, customary law. And the customary law is based on the practice of the people and opinal juris. And according to Hart, the important idea is about the internal point of view. So when people internalize certain standard of behaviors as their own standard, they will use this standard as a guideline of their behaviors and also use them to criticize or judge the values or whether the behaviors of others deviate from the stand of their own or not. So in this case, you can see that if there are enough number of people internalize certain rules, this will result in the social pressure, all right, that will be placed on the person who deviate from such rules. And this will create the force of law in the primitive society. And according to Hart, this internal point of view is the basic of the creation of rules. All right. However, this model might not be effectively applied to the modern society where a lot of people live. I mean, there exists uh, millions of people in the one state. So we it it impossible, virtually impossible to count all the all opinions of the people. All right, in the process of making law. So in the modern society, according to Hart, it is the internal view of of the officers that count towards the creation to the determination of what law is or not. And this lead to his famous concept of rule of recognition. All right. However, in the modern society, if there is a clash between internal point of view or of the officials or the external point, and internal point of view by the people, this will lead to the unhealthy society. And if the clash or conflicts is high enough, that could result in the revolution or the riot against the government, for example. So, according to Hart, law is based on the social rule, social fact. So, which means that it's based on the internal point of people or officials at the gate, maybe uh, on what law that they have internalized at their standard of behavior, right? So, according to Hart, law is based on the social rule, social fact, as law is a social standard internalized by people in primitive society and by officials in a society with a legal system or a model system. All right. There is some mistakes. I'm sorry. Standard internalized. It should be a letter D on this. So in this video, I have talked about some accounts from both schools, legal prosecution, and national law school. I hope that this will help you to understand more about the two schools. All right. So in the next video, I will talk about human rights as a national right.